Now we come to the last topic for the law of agency, that is termination of agency. Penamatan hubungan kontrak of agency between the principal and the agent. The objective of this topic are, first, the student will learn how and what are the situations an agency is terminated. You are going to learn about what are the modes on how an agency relationship is terminated between the principal and the agent. Second, whether the agency is terminated or not due to those situations, because sometimes in certain situations the agency is not terminated due to some exceptions to that situations. And third, whether the principal is still bound or not to the contract when the agency is terminated. So these are the objective of the topic of termination of agency. Meaning the students has to find out what are the modes or how the agency is terminated, and then whether that termination is effective or not. Because you need to know if the agency is terminated, the effect is that there is no more relationship between the principal and the agent. And of course, when the agent make contract, it is no longer binding upon the principal. So that's why it is important for you to know what are the situations and what are the exceptions to the termination of this agency. How the agency is terminated. Agency is terminated in these two following manners. First is by the act of the parties, either by the act of the principal or the agent or both. Meaning, the agency is terminated atas tindakan antara principal dengan agent. Second, by operation of law, melalui kuasa undang-undang. Meaning, the agency is automatically terminated because of the law which is provided under the Contracts Act 1950, because of the provisions provided under Contracts Act 1950. Okay, now we come to the first manner on how to terminate the agency, that is by the act of the parties. By the act of the parties, divided further into three ways. First is by mutual consent, persetujuan bersama antara principal and the agent. Second, by unilateral revocation or termination by the principal, meaning by the act of the principal who wants to terminate the agent. So unilaterally, atas tindakan sebelah pihak of the principal wants to terminate the agency. And third, by unilateral renunciation by the agent, atas tindakan sebelah pihak oleh agent tersebut, yang mana the agent wants to renounce his duty, hendak menarik diri. Renunciation ni maknanya penarikan diri daripada menjadi agent. These are the ways how the agency can be terminated by act of the parties. Okay, we go to the first one is by mutual consent. Mutual consent means persetujuan bersama. Both parties, that is agent and the principal, they agreed to terminate their agency relationship. So once both of them agreed mutually together saying that they want to terminate their agency relationship, the agency is terminated. There is no more relationship between them, no more rights and no more liabilities under the contract of agency. Meaning, principal is no longer bound to the contract made by the agent, and the agent has no longer any duties or liabilities to be performed under the contract of agency. Second, by unilateral revocation by the principal. This is provided under section 154. So this happen where the principal unilaterally, secara tindakan dia sendiri, wish to revoke or terminate the authority of the agent. So the principal may revoke the agent's authority at any time dengan syarat before the agent has exercised the authority. So principal boleh terminate agent bila-bila masa, tetapi dengan syarat agent belum lagi menjalankan tugasnya ataupun kuasanya by virtue of section 156. And then, in order to revoke, principal must give a reasonable notice to the agent. mesti memberi notis penamatan kuasa ejen tersebut secara munasabah. This is provided under section 159. Reasonable notice here means it depends on the facts and the circumstances of the parties by looking into their relationship, for how long the agency had been existed. For example, in the case of Sohrabji, the agent was terminated by the principal with a 3.5 months notice, but it was held that the termination notice was not reasonable, and the court held that the agency can only be terminated by 2 years notice because the agency had lasted for more than 50 years. Agensi tersebut telah wujud sejak lebih daripada 50 tahun. Is there any exception to this? Generally, yes, principal may terminate the agent at any time, provided agent has not yet performed his authority. However, there are certain situations where the principal is prevented. Principal dihalang or principal cannot revoke the agent's authority. Or even though the principal try to revoke the agent's authority, try to terminate the agent, still the termination is not effective. So this is the exception. Okay, what are the exceptions? First, where the agent himself has an interest in the subject matter of the agency. Agent sendiri mempunyai kepentingan, has an interest. Interest kat sini bermakna kepentingan in the subject matter of the agency, atas perkara yang dikontrakkan bawah agensi tersebut, dalam hubungan agensi itu. Here it means when the agent himself ada kepentingan dalam perkara yang dikontrakkan bawah agensi tersebut, principal cannot terminate the agent. This is by virtue of section 155. And for this, you can refer the example from the illustration A to section 155, and also from these two cases, Smart versus Sanders and Firth versus Firth. Okay, we go into the first one from the example of the illustration A. From this illustration, it provides that A gives authority to B to sell A's land and to pay himself out of the proceeds the debts due to him from A. So here A cannot revoke this authority. Okay, I explain further in the form of illustration here. Let's say we have Abu who was indebted, berhutang dengan Badrul for 20,000. So in order to pay this debt to Badrul, Abu appoint Badrul, give authority to Badrul, saying that Badrul, please sell on behalf of me my land. So maknanya kat sini Abu ada tanah dan dia lantik Badrul to sell the land on behalf of him. So in this situation, it means Badrul is the agent and Abu is the principal. Then Badrul later on managed to find a buyer. The buyer is the third party and sell to the third party the land for the price of 70,000. And it was agreed under the agreement between Abu and Badrul, where once Badrul sold the land to the third party, the proceeds hasil daripada 70,000 ni, 20,000 will be paid to Badrul for the debt of Abu. So maknanya hasil daripada jualan tanah ni, tanah principal that is Abu, it was agreed that 20,000 akan diambil daripada 70,000 ni, bayar Badrul untuk hutang Abu kepada Badrul. So here it means that Badrul has an interest, ada kepentingan in the subject matter of the agency. Badrul ada kepentingan. Kepentingan dari segi apa? Maknanya, duit dia 20,000 ada dalam hasil daripada jualan tanah Abu sebagai bayaran hutang Abu kepada Badrul. So here Badrul has an interest in the subject matter of the agency. So in this situation, boleh tak Abu terminate Badrul? Tak boleh. Badrul cannot be terminated because he has an interest in the subject matter of the agency. So this is the first illustration, first example where an agent has an interest in the subject matter of the agency, and due to that, principal cannot terminate this type of agent. Even though Abu later on tried to terminate Badrul, that termination is not effective. So the contract is still binding between Abu and the third party, still binding upon Abu. That is the first example where agent has an interest in the subject matter of the agency. Another example is in the cases of Smart versus Sanders and also Firth versus Firth. This is regarding a factor. Factor kat sini maknanya sejenis agent dipanggil factor. How this factor do his business is like this. Let's say we have a principal who have goods, who have a lot of goods to be sold, and this principal appoint the factor to sell the goods to third parties, to the customers. And the way how this factor operate his business is where the factor, he take the goods from the principal and pay certain amount of money to the principal as a security, sebagai wang jaminan upon the goods. Ni maknanya principal, dia ada barang yang banyak dan serahkan kepada factor untuk dijual pada third party, pada customers. Tetapi factor di sini, dia beri wang jaminan sebagai satu security. Yang barang-barang tu berada pada factor, so dia jamin the safety of the goods and also dia jamin yang dia akan jual to the third party. And after the goods were sold to the third parties, to the customers, then the factor will get the money back from the principal. So that's the purpose of paying the security for the goods. So in this situation, since the factor himself has paid certain amount of money to the principal for the security, jaminan ke atas keselamatan of the goods here. So it means this factor has an interest, ada kepentingan in the subject matter of this agency. Jadi, when the factor has an interest in the subject matter of the agency, the principal here cannot terminate this agent. The factor cannot be terminated because he has an interest in the subject matter of the agency. Why? Because he himself has paid certain amount of money to the principal for the security of the goods. This is another example where an agent cannot be terminated because agent has an interest in the subject matter of the agency. Okay, the second exception where principal cannot terminate the agent is where after the authority has been partly exercised by the agent. So even though it was partly exercised, belum habis buat kerja lagi, baru setengah jalan, dah mula buat kerja, principal cannot terminate the agent because agent has partly exercised the authority. Okay, third, the notice of termination only effective when it comes to the knowledge of the agent and the third party. Principal has the right to terminate the agent, and how to terminate must give a notice, must give a reasonable notice, surat ataupun notis penamatan kuasa by the principal. However, so long as this notice ataupun the knowledge about the termination of the agent did not reach the knowledge of the agent as well as the third party, the termination is not effective. So katakanlah, principal dia dah hantar notis 1 hari bulan Oktober. And then on the 2nd October, the agent contracted with the third party on behalf of the principal. Only on the 3rd October, the agent and the third party has the knowledge of the termination of the agent. The notice of termination is only effective when it comes to the knowledge of the agent and the third party. That is on the 3rd. Sedangkan on the 2nd, contract pun dah been made between the agent and the third party. So the contract is already binding upon the principal on the 2nd October. Finally, the third way how to terminate the agency by act of parties is by the unilateral renunciation by the agent. Kali ni, agent pula nak tarik diri. This is also allowed, where agent may renounce his duty under Section 154. So the way is that the agent must give a reasonable notice. In order to renounce his duties, he must inform the principal that he wants to renounce his duty. Otherwise, the principal is entitled to damages. Because if the agent failed to perform the duty, the principal may sue the agent for damages. So that's why agent, if he wants to renounce his duty, he must give a reasonable notice to the principal so that the principal has some time to find another new agent and so that his business will not be interrupted. So if the agency is for a fixed term, agent is liable to compensate the principal for any premature renunciation without sufficient cause. So maknanya kat sini bila principal melantik agent for a fixed term untuk tempoh yang tertentu yang dah tetap. Contohnya for 1 year or 2 years. So kalau agent tarik diri sebelum habis 2 tahun tu without any sufficient cause, tanpa alasan yang menasabah, principal may sue the agent for compensation. Absolutely, this is because it will cause difficulty to the principal because his business interrupted, business dia terganggu disebabkan agent tak menjalankan kerja dia. In short, an agent may renounce his duty as an agent. However, he must give a reasonable notice to the principal. Otherwise, the principal may sue the agent for damages. To sum up, there are 3 ways to terminate the agency by the act of the parties. One is by mutual consent, persetujuan bersama dua-dua pihak, that is the principal and the agent. And second, by unilateral revocation by the principal yang nak terminate the agent. And third, by unilateral renunciation by the agent. Agent tarik diri daripada agency.